Well, hello everyone. Welcome to the Global Advertising Law Year in Review for the year 2022, brought to you by Gala. Today we will be going around the world with six distinguished lawyers in advertising law. I'm joined today by Jose Antonio Arochi of Arochi and Lindner in Mexico, Caroline Bouvier of the firm Bernard, Hertz, and Béjot in France, Baran Güney of Güney Partners in Turkey, Jaclyne Reive of Miller Thomson LLP in Canada, and Julika Wahlmann Smith of Hesketh Henry in New Zealand. And I am Alexandra Megaris from Venable LLP in New York. And I will be serving as a moderator since we'll be switching gears every 13 minutes or so. Today we will have high-level presentations from each of our speakers recapping 2022 and the hot topics in advertising law. We welcome you to submit questions. You can do that through the chat feature or the Q&A feature. We'll be monitoring that, and if we get to it, we will certainly do so. And with that, I will pass the baton to Jaclyne Reive, who will tell us about what was going on in Canada in advertising law.
Thank you. My name is Jaclyne. I'm a partner in Miller Thomson's Toronto office. Perfect, slides are moving. So today we're going to be talking a little bit about changes to Competition Bureau matters, some changes from the privacy perspective, as well as labeling changes in the food and NHP spaces. So let's talk a little bit first about green advertising and environmental matters. So in January of this year, the Competition Bureau announced that it negotiated a consent agreement with Keurig, and I'm sure many of you have already heard about this. This regarded concerns over allegedly false or misleading recyclability claims on their website with respect to their K-Cup pods. So under our Competition Act, we have provisions that are both general, civil, and criminal that relate to preventing false and misleading environmental claims. It's just under our general misleading advertising provisions. But essentially the Bureau concluded that the single-use K-Cup pods, the claims related to recyclability were considered to be false or misleading because with respect to certain municipal recycling programs, the pods couldn't be recycled in the manner that it was suggested that they could be. And this was particularly for provinces outside of BC and Quebec. And there was they also had concerns with respect to the way that the pods were being told to be prepared for recycling. So essentially what ended up happening was they agreed to a settlement, which included a $3 million administrative monetary penalty, and also publishing corrective notices about the recyclability of the pods on various platforms and publications. So really what this means is just making sure that as an advertiser, a manufacturer, that your marketing claims are true in all of the relevant areas where the products are sold, but also considering the general impression that your consumer is going to have with respect to what it is that you're saying, including the use of images or symbols like the recyclability symbol. And then also in this area, the Competition Bureau recently has been placing an emphasis on greenwashing claims and related enforcement over the past year. So as I'm sure you'll hear later as well, greenwashing refers to environmental or sustainability attributes of a product or a service that are considered to be misleading. The Competition Bureau earlier this year archived its enforcement guideline that related to environmental claims, and it hasn't published a replacement just yet. But it did announce in the fall of this year that it is going to be taking investigations into a financial institution with respect to allegedly misleading claims related to their commitment to reduce emissions and address climate change, as well as natural gas producers regarding an advertising campaign that alleged that the products that they were selling were sustainable and clean. So again, this really just suggests that businesses should start focusing more on making sure that their environmental claims are meeting just general advertising requirements so that they're accurate. If there's qualifications that need to be added, that those are done, and that they have the substantiation that they need for those claims. So we're going to move to the next slide here. So there's also been changes to the Competition Act, and now drip pricing is specifically recognized as a deceptive marketing practice, and it's prohibited under the civil and criminal provisions of our legislation. In Canada, drip pricing is considered to be the practice of offering a product or service at an initial price that is ultimately not possible to obtain, usually because there's some type of fixed fee that is hidden at the time that it's initially advertised, or it's in a fine print, or it's added on later in your checkout process. In the past, you could still have drip pricing claims, but they were brought under our general misleading advertising provisions. And the commissioner had the burden of basically proving that they were false and misleading. And kind of the cases we saw in this area were car rental and online ticket sales. On the slide, you'll see some of the provisions now that relate to the penalties for drip pricing. And you'll also see there's kind of a difference between civil and criminal. And in order for it to be considered criminal deceptive marketing, it has to be done in a knowing or reckless manner. So that's kind of what the difference is there. So next we'll move on to our privacy changes. Okay. So first in Quebec, we have Bill 64, which was introduced earlier in 2022. Sorry, just having an issue here with my slides. There we go. Okay, so Bill 64 is basically being introduced in 3 stages. So the first changes came into force in September of this year. The majority of the provisions are going to be coming into force in September of next year. And then the remaining things will be in September of 2024. It basically aligns Quebec's legislation with the rest of Canada and other countries as well, just increasing rights and control over personal information for individuals that are located in Quebec. But it is important to note that this legislation will apply irrespective of whether or not the organization itself is established in that province. So if you are collecting personal information from somebody who is located in Quebec and that activity is taking place there, this legislation would apply. And so some of the things that it does is increase fines for non-compliance. It makes it an offense to fail to take appropriate security measures. Similar to our federal legislation in Quebec, you now have to report data breaches, as well as designate a privacy officer. And then, as I mentioned earlier, just kind of bringing the legislation in line with what we're seeing at the federal level. So making sure that individuals are aware of the purpose of collecting the personal information, how it's being collected and what is being collected and how it's being used, making sure that that's set out in a privacy policy. And then one interesting change is Bill 64 also now requires organizations to conduct a privacy assessment. And this is kind of like an impact assessment of the systems that are used to handle personal information if it's going to be transferred outside of the Quebec border. And so this is kind of a new requirement. We don't have a similar thing at the federal level, and it could be onerous. So it's just kind of something to keep in mind if you're doing business with Quebec consumers and individuals, and if you are transferring that information outside of Quebec. With respect to our federal legislation, so we previously last year tried to amend the federal legislation, and then that didn't end up happening. And so now Bill C-27 has been introduced again as an attempt to amend the federal legislation, and it's at its second reading in the House of Commons last time that I had checked. And basically at a high level, it's updating PIPEDA, which is our federal private sector privacy law. It introduces a number of administrative monetary penalties for provisions. It introduces a private right of action. The powers of the tribunal have been increased, and they've created this exception now for legitimate interests. So if the legitimate interest outweighs any adverse effect that could potentially happen on the individual, that's supposed to be a new exception. So we'll see how that actually kind of plays out in practice if this legislation ends up being passed. There's new protections that relate to children's privacy. So parents and guardians are now supposed to be expressly authorized to exercise rights and recourse on behalf of their child. And the personal information of a minor will be deemed sensitive information. And already from a guidance and interpretation perspective, we've kind of been doing that, but now it would essentially be codified. Definitions for de-identify and anonymized have been clarified. If this goes through, we'll have that actually in there in writing. And finally, there will also be the introduction of a new AI and Data Act, which will basically govern the way that AI systems are designed and developed and used in Canada. And so that's kind of what the updates are on the federal level if that legislation ends up being passed. So next we'll talk about the labeling changes for natural health products and foods. So for natural health products, we saw in June of 2022 amendments to the natural health product regulations, and these were really to kind of bring the legislation in line with other countries globally. And also from my perspective, I think things now are a little bit more similar to the way that we see food labeling. And I'll kind of touch upon that as we go through the slide here. So most of the changes related to content and formatting. So on the content side, allergens now need to be disclosed as well as their source ingredients. Gluten in any amount needs to be disclosed on the label, as well as any added sulfites that are in excess of 10 parts per million. And so there's this new requirement for a product facts table that I'll talk about in a minute. And there's supposed to be a warning section in that product facts table, and allergens have to be disclosed underneath there. And so that's where that information would go. Also under that warning section, if the product contains aspartame, it now has to be disclosed as well. And finally, they've modernized the manner of disclosing contact information for the manufacturer or importer. So before it used to be that you had a postal address that was required, and now you can put a telephone number, an email address, or a website. In terms of the formatting, so as I mentioned, there's now a requirement to have a standardized product facts table on your label. And again, this to me is very similar to what you would see with food labels, where it's a standardized format. You know to look there for all of the information related to your nutrition value for the food. So this isn't talking about nutrition value or anything like that, but all of the information that you would typically see in different places on your label, like the medicinal ingredients, the uses, warnings, directions for use, storage information, contact information, it now all has to be in the standardized product facts table format. And the important thing to note is that the information there cannot go beyond Health Canada's terms of market authorization for that product. And you also can't include any like marketing or promotional vocabulary within the product facts table. And then there's also specific requirements in terms of like font size, placement, background contrast, and so on. And then there are some flexibilities and exceptions to this depending on the size of your label, for example, or if you're using an innovative label. So if you have a partial facts table on your label, but then you have a leaflet inserted, then that would be like one way around having everything on your label. So there's kind of ways to work with this if needed. And there is a transition period. So for products that do not yet have a product license from Health Canada, they have 3 years from the date of the legislation to transition. So that brings us to 2025. And for products that already are licensed, they have 6 years. So there's a little bit more time. But of course, Health Canada would prefer that, you know, if you have the ability to change your label sooner, that you do so. And then just finally, our last topic for today is food labeling. So this year, Health Canada published regulations amending our food and drug regs to introduce a mandatory front of package nutrition symbol. And this is required on all prepackaged foods that are high in sodium, sugar, or saturated fat. So this came into force in July of 2022, but there is a transition period. So the changes are not actually required to be on the label until December of 2025. But again, if you want to update your label sooner, you can. Essentially, there's the symbol that you see on the slide now has to be on the front of those prepackaged food labels. And prepackaged would mean that the food is in a way that you would see the consumers obtaining the food. And in terms of whether or not you actually need to make this disclosure, it depends on a couple different factors, but there's a different threshold based on the reference amount. So for general foods, if the daily value meets or exceeds 15% for sodium, sugar, or saturated fat, then you'd have to have that. However, if your reference amount is small, so let's say like 30 grams or less, then that 15% changes to 10%. And again, there are exceptions to this. So some are nutrient specific. So if your food is high in fat, but it's, you know, a good fat, they are fine with you not having that label on there. There's technical exceptions. So if the product doesn't need a nutrition facts table, then you might not need to have this either. And then there's some practical exceptions. So for example, if you're selling table salt, you don't need to have this on there because again, it would be redundant. So that's kind of the changes we're seeing from the food labeling side. And that's all for today for Canada. Obviously, there's other changes that have happened throughout the year as well, but these are kind of some of the high-level key changes that we've seen. Thank you.
Thank you, Jaclyne. And if we could just move on to the next slide, we will move to the European continent, and Caroline, take it away.
Yes. So I'm happy to share some insights regarding hot topics in France, and in particular advertising for alcoholic beverages, advertising for motor vehicles, and sustainable development and greenwashing in ads, which is, I understand, a hot topic in all countries. So just basically, I will rapidly present the legal framework of advertising for alcoholic beverages in France. A drink is considered as an alcoholic beverage by French Health Code if it contains more than 1.2 degrees of alcohol. And ads for alcohol are strictly regulated in France. It's not a black market, but it's very strictly regulated market. And basically what is not specifically allowed is prohibited. And you have to feature a health message on the advertising. So abuse of alcohol is dangerous for your health and intake moderately. And Health Code provides for a limited list of information which is allowed, and basically the ad must be objective and informative. And there is a limited list of media allowed. For instance, TV and cinemas are banned media. Internet is allowed under certain conditions, and sponsoring is prohibited. And I think that New Zealand will address that later on. So it would be interesting to see how it will be addressed in other countries. So I wanted to share with you some, not a new topic, but a new trend, because promotion of alcohol-free beers is increasing in France. And when they are advertised under the name of an alcoholic beverage brand, the ad must display the health message, because an ad for alcohol-free beverage by reference to an alcoholic beverage brand is deemed in France an indirect ad for alcohol. As a result, the health message must be displayed on the ad. So for instance, in these two posters, there is the health message featured, even though they are advertised in alcohol-free beverages, because the alcohol-free beverages is branded with the name of alcohol brands, famous beer brand like Desperados and Heineken. So you have a health message, even if the ad is alcohol-free. So it's very specific to France. And that's why I wanted to share these examples with you. The marketing of hard seltzer is a really hot topic in France nowadays, and this year in particular. Usually these drinks contain more than 1.2 degrees of alcohol, so they are deemed alcoholic beverage under the Health Code. So they must comply with the general principle that I presented to you. And there are currently a lot of ads which are not compliant, and French governmental agencies and French state are concerned by the way these drinks are promoted, because they are presented like good for health, or which fit with healthy lifestyle, or with low calories, or natural, whereas greenwashing or health claims are banned for advertising for alcohol. So the ad on the left side of the slide is clearly not compliant, because there are wordings and reference which are not listed by Health Code as allowed information. You have, for instance, good drinking has become a care, or fill your fridge, or surprise your taste buds. So it's clearly banned in France to use these wordings. The ad on the right side of the slide is compliant, because there is no reference to water, but sparkling beverage instead. There is only objective information pertaining to the composition of the product. There is no else claim, and the product is promoted promoted in connection with a festive moment, as opposed to the other one, which is not compliant. And the ad in the middle of the slide contains nutritional claims. It's possible to promote and to use nutritional claims, but under certain conditions which are not met in this example, because the use of words such as light or low calories is possible for alcohol, but the claim must make a factual alcohol strength comparison with a standard or non-light product, and the claim must mention the characteristics or the reasons which explain the calories reduction. And regarding hard seltzer, it's currently clearly a hot topic because a draft bill has been filed with the French Parliament recently to ban the use of the word water to advertise hard seltzer. So it's clearly that there is clearly something more to come on this topic for 2023. I wanted to address advertising for motor vehicles because there has been major changes which entered into force in March 2022. There are now new information to be displayed on ads for motor vehicles. The information must be provided in each advertising correspondence intended for private individuals, for printed advertising distributed to the public, billboards, the press, advertising, broadcasting, cinemas, by television, on radio, and even on online public communication. And this new information must be displayed even for ads promoting hybrid or electric vehicles. So now you have to add two messages or two types of information. One is the disclaimer, an eco-friendly message, and the other one is the CO2 label. So you have an example on these slides of how it should look like for print ads. So regarding the disclaimer, the wording of the message and the signature in the tagline to be used identically without any modification is as displayed in my slides. Of course, you have to use the French version of this wording. So for instance, for short trips, prefer walking or cycling, and you have to add a specific hashtag, or think about carpooling, or on a daily basis, take public transports. And in each case, you have to have the hashtag, the French version of the hashtag se déplacer moins polluer. Except for radio, you are not obliged to use the tagline. But these formulations are to be used in each advertising campaign to guarantee by type of advertising medium the regular appearance of each of them, and to ensure an equitable rotation during broadcasting. And there is a tolerance of more or less 10%. So you have to use these three messages on an equivalent basis. So there are fines if the advertiser does not comply after he received a notice to comply. It's 50,000, a fine of up to 50,000 euro per broadcast, and it's multiplied and it can reach 100,000 euro per broadcast if the breach is repeated. So now let's, no, sorry, I wanted to talk about briefly a CO2 label, which is compulsory. So it must be inserted in any advertising for private car. It must comply with several featuring, size and color requirements. So I won't bother you with all requirements, but basically you have to take the set of 7 colored arrows, which correspond to the 7 classes of CO2 emissions. You have to insert the CO2 emission rate of the car at stake, and you must feature the rates in gram CO2 per kilometers, in white, in bold, and in specific typo in so it's very constraining. So we are here to help our clients to implement this very strict regulation. So sustainable development and the prohibition of greenwashing are still a hot topic in France and a growing concern. The SRO, the French self-regulatory authorities, issued guidelines concerning sustainable development, and they improved and amended the guidelines in 2020 to reiterate the general principle of fair, honest, and truthful ad when using a sustainable development claim. For instance, a claim such as this product helps protecting environment should be preferred to a more general statement like this product aims at protecting the environment. The scope of these guidelines has been extended to all ads. So even though the ad does not contain green claim or sustainable claim, the ad will have to comply with the general principle set forth in these guidelines. To summarize, the three key principles are the following: the advertiser must show responsible behaviors, must not disparage alternate eco-friendly alternatives, and must use a proportionate message claim in line with the sustainable development initiative that he's having. So I will share 3 examples of this principle. The first one, so be responsible. Lego launched a cute ad a couple of years ago showing kids, I hope that you are able to properly see the image, but showing kids who had built a scene with their Legos and ice in the freezer located in the kitchen. So there was no claim pertaining to sustainable development. And nowadays, with these new guidelines, even though this ad does not contain any green claim, it could be challenged on the ground of the presentation of a behavior which is not planet or eco-friendly, because it clearly shows waste of energy. So if this ad was to be broadcast today, it would be deemed not compliance with the recommendation or guidelines that I described to you. So it is interesting to see how trends are moving following these guidelines. So this ad has been deemed recently not compliant and violating Article 9.2 of these guidelines pertaining to sustainable development, because this article states that advertising must not discredit the principles and objectives, nor the advice or solutions commonly accepted in the field of sustainable development. And this ad clearly gives a negative image of public transportation, because you see people who are stuck at a crowded bus stop. So this ad encourages people to favor transport by scooter and to encourage them to buy a new scooter, which is a much more polluting mode of transport. So this that is the reason why the ad has been deemed not compliant. And the last example that I wanted to share with you is a quite recent one, because the SRS juries held that during summer, it was in July 2022, that the jury held that this ad is not compliant with these guidelines, because I'm not sure whether you can see the message in the ad, but the ad alleged that the sailor jacket it promotes cleans the oceans. The aim of the ad was to refer to 2 initiatives that are taken by the brand IKKS pertaining to sustainable development. The garment is made of 50% of polyester from the recycling of plastic waste recovered from oceans. And the second action is that 5% of the revenues generated by the sale of the jacket is donated to an association, Sea Cleaners, to support the project of building a ship capable of collecting, treating, and recovering ocean plastic waste. So according to the SRS jury, while consumer cannot be misled into believing that the seller jacket does not in itself clean oceans, but such a claim suggests that by purchasing the product, consumers will directly contribute to reducing ocean pollution or even cleaning oceans. So the claim has been deemed violating the veracity and proportionality principles that was by these guidelines, because it is not possible to claim that the purchase of the jacket will have such an effect with regard to the entire life cycle of the product. So given the environmental impact of the advertiser's activity, and despite the interest of these two actions, it cannot be alleged in a global and non-relativized way that IKKS would be part of an environmentally friendly approach. So clear this message, this claim is disproportionate and should have been more nuanced. And one option would have to be to use the wording help cleanings, but not cleans. Maybe this would have been deemed more accurate as regards to the impact of the manufacturer. That's why I wanted to present for France. Let's move to another panelist. Thank you.
Thank you. The next slide, please. And we will take it to Jose in Mexico to give us his updates.
Thanks, Alexandra. Thank you very much. How are you guys? How's everything? Like in Mexico, there's not a marketing or advertising legal frame in a way. There's not a rule of law that establishes or talks about advertising. But in this past 2 years, there is a law that has come into effect that has affected or affects agencies, media hubs, and advertisers, and the relationship between the three of them. And this law is a law for promoting transparency and preventing and combating malpractice in the contracting of advertising. Unfortunately, we have a new administration that has been in power for the past 3 years, and they are trying always to obtain money out of us, private sector. And this is a law that has only 13 articles, and really it establishes the relationship of how there is interaction between advertisers, like I was mentioning, media hubs, and agencies. So the main purpose of it is, like I mentioned in my slide, is establishing rules for the use of advertising spaces so the advertiser can protect herself, and avoid bad practices between her agency and the media. At the end, what we did in a more practical way, and just so you understand, is that every company that has a relationship in Mexico that is one of these economic agents, well, we did 3 things for them in a matter of enforcement. We modify the contracts they had between the 3 of them. So if I was an advertiser and I had a contract with an agency or with a media hub, we did contracts, or we drafted contracts, so we did not came into the malpractice of the law. We changed or modified the way the companies were established, because the law is really done with, I always say it was done so badly. It took them like a weekend to do it and came into effect. And to be honest, it was something that has affected the industry in Mexico a lot. And all of those economic agents that have been in Mexico or have a relationship in Mexico. The most important thing is that we filed injunctions regarding this particular law, because obviously this is a law that goes against uh, constitutional rights. So obviously labor issues, commercial issues, and this injunction has arrived or has gotten the attention of the Supreme Court. So next year, mid-year, there will be a resolution from the Supreme Court establishing if this law was constitutional or was not constitutional. So it's so big in the industry that we'll have to wait at mid next year to see if this actual law will be considered by the Supreme Court constitutional or not. So the main axes for this law are that agencies are prohibited from purchasing advertiser space for resale to advertisers, which is the day by day in our industry. So at the end, they're trying to change the industry. It's I always say this. It's if I'm an attorney and I'm hired to be paid on an hourly basis, and the Mexican government tells me, Jose, you cannot be paid on an hourly basis. Now you're gonna have to be paid on a retainer monthly basis. At the end, I'm not doing nothing incorrect. I'm not doing nothing that goes against the law. So they're blocking me, commercially speaking. So at the end, they're blocking the way the agencies, the media hubs, and the advertiser can interact between the three of them. Then another acts regarding agencies is that they cannot receive any additional compensation other than the fee charged to the advertiser. Media owners are barred from granting discounts to agencies, which discounts are something that in the industry are done in a day by day. That's what they do in a day by day. And that's the relationship between these three economic agents. And then a single entity cannot provide services both to media owners and to clients with the purpose of avoiding conflicts of interest. The media must invoice the advertisers directly, which this has been a prime issue in the way practically the agencies, media hubs, and advertisers can interact. So at the end, it's very complicated. Then it comes to the scenario that we have penalties. So there's penalties that if you do not comply with this law, which it's important to mention, this law has not been enforced at all. The Mexican antitrust authority is the Mexican authority that is in charge of doing all the enforcement of this law. And there hasn't been one case in Mexico that regarding the enforcement of the law. So at the end, what I'm telling is that we have worked in the past year and in this year doing all the compliance regarding how we can go according to what established in the law, but there's no enforcement. But what I want to tell you is the penalties. It says in the law establishes that 2% of the offender's income, if there's not a service provision contract, an invoice is not delivered directly to the customer, or results are not delivered. But the law does not establish a 2% weekly, annually, monthly. So at the end, it can have an issue where if I'm, for example, a media advertising authority that, agency that is billing $200 million, that it can be 2% of those $200 million. At the end, the law is so ambiguous that at the end, the economic agents that are part of this law can obviously have a penalty that can affect them very much. So like I was mentioning, COFECE, which is the Mexican antitrust law, is the Federal Economic Competition Commission, will be responsible for imposing the corresponding sanctions that can be up to 4% of the offender's income. So it can be from 2 to 4%, but the law is so ambiguous that it doesn't talk about if this income is, like I was mentioning, annually, monthly, weekly, or if it's just related to the relationship between the agency and the media hub, or the agency and the advertiser. It's just this law was so important for us last year and this year, because at the end, like you see, it can affect a lot the economic agents that are part of this legislation. can we move to the other? And this is just a little bit about what I was telling you, and about what are we, how this authority COFECE comes into effect. There was a constitutional issue between the Supreme Court, where the Mexican antitrust authority said to the Supreme Court in Mexico, "I'm not competent to hear this type of cases," and they filed a constitutional challenge. And also the Federal Institute of Telecommunications said, "Yes, I'm competent to be part of this law," because obviously there's a lot of interest regarding this law. And at the end, the Mexican Supreme Court said, "Yes, COFECE, Mexican Antitrust Authority, you are the responsible, and you will have to make all the enforcement of this law." There was approximately 300 of constitutional injunctions filed before the competent authority. The majority of rulings issued so far have determined that this law is unconstitutional. So in Mexico, you file before the tribunal, and then the tribunal can hear about it. But the law has been attracted to the Supreme Court, which is a big deal. But the Supreme Court, if the Supreme Court of our country decides correctly, they will obviously establish that this law is unconstitutional for these economic agents. Then, after this law came to effect, there is a local law in Mexico that has come into effect, and it affects all of the advertisers that are promoting all the billboards around Mexico. So the main issue, or the main goals, is to reduce visual pollution, avoid risks in private homes due to the installation of heavy structures. Obviously, if you've been to Mexico City, there can't be one more person that can come into this city. So everybody is very crowded. Everything is very crowded. At the end, I understand the background of the law, but again, because it's a local law, I think it affects a lot the day-by-day of the advertisers. There has not been enforcement of the law as well. There's just like media issues in the day-by-day, where the Mexico City government says that, for example, Samsung is using billboards all over the place, and they cannot promote visual landmarks. And at the end, the authority is not doing any type of enforcement. So at the end, obviously, they know that it's a law that goes against the way that the advertisers can interact in the day-by-day. The provisions also is the use of drones for advertising purposes. So at the end, like in our country, there in Mexico City, there's a lot of promotions. For example, the other day there was a promotion for Disney in the Reforma area, which is like our Champs-Élysées. That's something very, very different to compare. But our Champs-Élysées of Mexico, which is Reforma, they did with drones, Buzz Lightyear going down all of Reforma. So at the end, the law that came into effect would block this type of day-by-day activities. And also, there's penalties from $28,000 to $71,000. There can be arrest to the legal representative of the company that is doing the advertising of the outdoor day-by-day activity. And there can be also a sentence of 3 of 6 years of prison for that legal representative that is doing this type of activities. My opinion regarding this law is that, again, I think the background of the law is fine, but you cannot limit advertisers that are doing the day-by-day without affecting the city. And at the end, of the city like Mexico is very important. They're blocking even buildings that are using colors, because they say that it's visual pollution. So at the end, it's very important to mention that these two laws, the law of transparency regarding publicity matters, and this local law, the outdoor advertising law of Mexico, are both the most important laws or issues that have arisen in Mexico regarding advertising. We have, or there is a bill that will come into effect in January, or that's what they say, for influencers. But at the end, in Mexico, important to say, we do not have a regulation. Our Mexican FTC, which is the Mexican Consumer Protection Agency, is not doing enforcement regarding advertising in a day-by-day. Right now that the World Cup came into effect, there was a lot of ambush marketing issues that at the end there was no enforcement of it. So I think the thing to criticize about my jurisdiction is that there's no hands. Like Alexandra can tell us, the FTC in the United States has a very day-by-day enforcement, and also goes against all the influencers, companies that are not going according to what the law establishes. And in Mexico, unfortunately, we do not have hands. So I think I'm done with my presentation. Hopefully, you like what I said, and thank you very much, Alexandra.
Well, thanks, Jose. Very passionate. Keep us posted on the status of that law. Looks like there's a lot coming. We will now hear from Julika from New Zealand.
Thanks, Alexandra. Hi, everybody. I'm Julika Wahlmann-Smith from Hesketh here in New Zealand. And today I'm going to give you a bit of an overview of what's been happening in the last year here in New Zealand. I'm going to touch on the themes that we've seen out of our Advertising Standards Authority, and then a bit of a focus on advertising alcohol, advertising to children, and then end on some standout cases that we have seen. So the themes that we've really seen in the last year in relation to our Advertising Standards Authority largely encompass things like misleading advertising. So this is always a significant issue that we see, and has continued to be so in the last year, with a significant proportion of complaints relating to advertisements being misleading. Another theme that we've still continued to see, which has really been more active in the last few years, is advocacy advertising. And a lot of that does still relate to COVID-related advertisements. Here in New Zealand, we still had a large amount of restrictions at the end of last year and the beginning of this year. And so we did see a lot of advocacy advertising from groups that were anti the restrictions, shall we say. So an example there is included in the slide. Voices for Freedom, who produced that advertisement, produced a raft of different advertisements which received a large number of complaints, with the ASA often finding that the advertisements were not prepared with a due sense of social responsibility, and caused undue fear or distress. We also continue to see a large percentage of the advertisements that were complained about were digital. So again, this is something that we've seen over the last few years and continues to be a theme now, with a large percentage of those related to social media. So advertising alcohol is something that has been under review for the last couple of years. So last year, we saw the introduction of the Alcohol Advertising and Promotion Code. This is one of our advertising standards code, which has three main principles, being social responsibility, truthful representation, and alcohol sponsorship and promotion. We saw 35 complaints made under that code in the last year, with the main focus of those complaints being that the advertisements were not prepared with a due sense of social responsibility. We might also have some new changes on the horizon, with a new piece of legislation that's been introduced very recently, the Sale and Supply of Alcohol Harm Minimisation Amendment Bill. Is a bill that has a raft of different measures in relation to the supply and promotion of alcohol. And one of those proposed measures is to remove the link between alcohol and sports. So here we do still see a lot of sports teams sponsored by alcohol brands. And it is seen as one of the ways that children in particular are getting exposed to alcohol brands, and there is some move to reduce that exposure. with the proposed measures, including prohibiting alcohol sponsorships and advertising on broadcast sporting events. So this piece of legislation is still very early on it's only just been introduced and had one reading, so there is still a lot to progress before we see it get passed into law, if it does. So it will be interesting to see. I imagine there will be, you know, a large amount of interested parties making submissions in this regard, because alcohol sponsorship is, of course, still one way that sports teams get funded. So it will be interesting to see how this develops here. So just to give you a couple of examples of cases that we've seen in this space, the first one was in relation to Woolworths, who run the Countdown supermarket chain, which is a large supermarket chain here in New Zealand. They have a very big online presence as well, with online shopping becoming ever more popular. And on their website, they advertise everyday essentials, which included beer and wine. So there was a complaint made that advertising beer and wine as an everyday essential was encourage excessive consumption and not be socially responsible. And the ASA agreed, and requiring the removal of beer and wine from the everyday essential description on the website. Another case was a Smirnoff Facebook campaign promoting 100 days, 100 ways to drink vodka. So again, complaints being made about this encouraging excessive consumption of alcohol and not being socially responsible. Smirnoff did respond to the allegation to say that it was not actually trying to encourage people to drink vodka 100 days in a row or anything like that. It was simply to highlight different ways that you could drink vodka that you might not have thought of before. However, this argument was not bought by the ASA, and they were also required to remove the advertisement. Another key area of focus is advertising to children. And so we've got a children and young people's advertising code. Our ASA codes in general get reviewed on a periodic basis, and this year this code was up for review. The review commenced earlier this year with a key focus on 4 different areas. The first of those areas is the age definition. So currently the code defines children as those under 14 and young people, those between 14 and under 18. And the intention of that split is to really recognise that different protections are required at different ages for children. So, for example, occasional food cannot be targeted at children, but it can be advertised to young people, provided it is done in a socially responsible manner. So there are some differences in how it's currently treated, and what the review is considering, or part of that consideration, is whether that age bracket for children, which affords the higher protection, should be changed, for example, increased to 16 or 18. So it'll be interesting to see how this develops. Obviously, if it were to increase, for example, to 18, you could have unintended consequences, such as the children being allowed to work in a fast food outlet, but technically the advertisement not allowed to see the advertising. So it will be interesting to see how that develops. The next area of focus is the application of targeting criteria. So at the moment, if you've got robust evidence to show that your audience is, so 25% or less than your audience is children or young people, as the case may be, then the ad will be deemed not to be targeting them. And so what this is looking at is the thresholds, the percentage thresholds, as well as how those targets will work going forward. So for example, we have a separate code in relation to alcohol advertising, which is a 20% threshold. So your audience needs to be less than 20% of minors in order to be considered not to be targeting minors. And so perhaps part of this review, it will result in consistent thresholds, so perhaps changing that 25 to that 20%. So it is something that we will see how that develops. And next area is brand advertising. So currently the focus is on goods and services, the advertising of specific goods and services in relation to this code. And the review is considering whether it should be applied more broadly, including to any advertising of just brand awareness effectively, as opposed to being tied down to a specific good or service. And the last thing is sponsorship advertising. Again, this is quite a big topic at the moment. So at the moment, this code just focuses on sponsorship advertising in relation to occasional foods. And the question is whether this will be expanded to other areas as well. So it will be an interesting place area to see how it develops. So I just thought I would touch on a few cases of interest that we have seen from our Commerce Commission. So our Commerce Commission is the regulator here that enforces our Fair Trading Act. Our Fair Trading Act includes various restrictions that would apply to advertising, including the prohibition of misleading and deceptive behaviour. So the first example that we've got here is an advertising campaign run by a large telco here in New Zealand, Vodafone. They advertised their superfast Fibre X broadband, did quite a broad advertising campaign for this. The problem was that the actual product that you were receiving under this Fibre X was fibre cable to the street and then effectively copper cable to your house. So not what we would normally understand as fibre broadband, which would be fibre all the way to your house. This was all, clearly described when you, sought further details, but obviously not in the headline claims. And while Vodafone did try to say that the use of X, so Fibre X, was would alert customers that it was a different type of product, that was not taken on board by the court, who there was in fact counter evidence to say that the X would perhaps suggest an enhanced form of fibre as opposed to a lesser form, as the case seemed to be. So it was the claims were held to be misleading under our Fair Trading Act, and a fine of $2.25 New Zealand million was handed down. This is in fact actually the largest fine that we've seen under our Fair Trading Act, and perhaps is the start of a trend of larger fines that we might see, and in particular where there's been extensive use of an advertising campaign that is considered to be misleading. The Commerce Commission is appealing. They sought an initial fine of 5.8 million, and so it is under appeal. So again, it will be an interesting one to see how it develops. The next case is, again, and this one was an online retailer. So we have quite a few of these retailers which do effectively a sales site which have a certain amount of stock on sale for a certain time period. So this one day they do daily sales. And so on their website, they've got a countdown that shows that the amount of time for you to purchase something is reducing, and it also shows that the stock available is reducing. So again, to create some sort of urgency for you to quickly make sure you purchase something and don't miss out on the product that you're after. In this instance, the product, the countdown of the product was just automated, so it was not in fact related to how much product was being sold at all, so effectively falsely creating a sense of urgency in respect of the product diminishing when in fact it was not. So they were fined 840,000 for displaying the false countdown timer relating to stock amounts on their website. So it is something for these type of websites to keep in mind, as it is something that our regulator is actively regulating and watching. So the last example that we've got here is, again, perhaps we find these relatively common here. A lot of people are doing their online shopping, and then you get a pop-up to say that somebody has just bought the product that you're looking at. Really, again, trying to create a sense of urgency, really playing on that FOMO or fear of missing out, and then making you want to buy something quickly because you think you might not be able to because all the other people are buying it. So in this instance, what happened is that the retailer had used or had purchased an overseas off-the-shelf product, which then created these pop-ups for them. Unfortunately, the way they were being done was they were unable to substantiate the fact that anyone was actually purchasing the product at all, let alone the people in the example. So once they received a letter from the Commerce Commission, they were apparently very cooperative and were quick to, I suppose, correct their ways and remove this from their website. And so this resulted in just a formal warning from the Commerce Commission as opposed to any fine at this stage. So it does show the merits of interacting with the regulator early and cooperating to the extent you can, should you get the unfortunate matter of being contacted by them in relation to your campaign. And so that's a bit of a wrap up from a New Zealand perspective. Hopefully you found something useful there. So thank you.
Thank you. That was very interesting. And some of the things that you touched on, I will be touching on as well. These pop-ups, etc. We will now turn it to Baran in Turkey.
Hello, everyone. This is Baran from Gün Plus Partners from Turkey. It is great to be here, and thank you all for participating. Because 2022 was a year with full of new developments in terms of advertising law in Turkey. I have a lot to share with you, but I restricted the content. I will just try to provide you with some kind of overview only. There are some important legislative changes. There are some new rules, new guidelines issued by the Advertisement Board. And again, there are some new rules providing a high level of scrutiny by the Advertisement Board, which took effect this year. First, I would like to provide you with a short summary of prominent developments this year. Some new legal rules were enacted for ensuring the effectiveness of Advertisement Board scrutiny over certain types of advertisements, which I will present later in the slides. The Advertisement Board also focused on issuing some new guidelines for detailing how the existing rules for some specific advertisement types will be applied. I will change the... sorry, okay. No need for the time being. First of all, in February this year, the advertising regulation was slightly amended. Some new rules for advertisements with price information and advertisements for discount sales, as well as some specific advertising rules for consumer reviews were introduced into Turkish law. Later in May, the guideline on advertisements containing price information, discount sales advertisements, and commercial practices was prepared by the Advertisement Board. This is an important guideline which we will review in detail. And finally, in October, Consumer Protection Law, which is the main law regulating the advertising law in Turkey, was slightly revised in relation to Advertisement Board's authority for possible sanctions, and the Advertisement Board has been entitled to block access to the online content which is violating the advertising principles in general. So let's overview some further details about the developments. Let me change the slide. Yeah, first of all, we will talk about the advertisements with price information and advertisements for discount sales. This is an important topic in Turkey. First of all, I would like to present some recent developments in Turkey, like that Turkey faced some serious inflation rates within the last year. So annual inflation in Turkey reached record of last 25 years and approached 100% approximately. So the prices for goods and services significantly changed and mainly increased, of course. So this is why the Advertisement Board and the Ministry of Trade, that the Advertisement Board, which was established within the body of it, decided to make some new amendments for protecting the consumers against advertisements with misleading price information and unfair commercial practices, like changing the prices unfairly and making fake discounts to consumers, which are indeed not discounts, just increasing the price and then making a discount, but which is not a discount at all. So well, the Minister of Trade made some amendments in the advertising regulation, and the Advertisement Board also issued a guideline for showing and enlightening how these rules should be applied and how the advertisements containing price information or discount sales advertisements should be broadcasted in conformity with the applicable rules. The most prominent rule, there are lots of rules, and the guideline and the amendments are really detailed, but I presented you some do's and don'ts, which are prominent in both the amendments and the guideline. The most prominent rule is that the lowest price applied within the last 30 days prior to the application of the discount should be taken as a basis in determining the sales price of any good or service before the discount. So the Ministry and the Advertising Board is trying to ensure that the consumers do not face sorry, I guess I'm interrupted now.
We can hear you now.
All right, thank you. Sorry for that. So the Advertisement Board and the Ministry is trying to assure that consumers are not facing misleading discounts and misleading price advertisements. Again, I would like to say that I also listed some important do's and don'ts here. For example, it is ruled that the words like up to, from, to should be included in legible sizes. And for example, the terms such as all, everything cannot be used unless a price or discount applies to all goods or services in a store or in a specific category presented by the vendor. The price must be the total selling price of the good or the service, including all taxes, of course. Sales prices should be stated as Turkish lira, or the abbreviation for Turkish lira, which is TL, TL, we say in Turkish, or with the symbol, specific symbol for Turkish lira. I guess this is the universal symbol for Turkish lira. If there are, for example, expenses arising from the delivery of the goods, this should be clearly specified and should be informed to the consumers. If the amount is not certain, then the calculation method for these additional expenses should be notified to the consumers. If there is a time or stock limit, this should be again clearly stated in the advertisements. In discount sales advertisements, the price before the discount, the start and end dates for the discount should clearly again be informed to the consumers. So what I would like to say that these principles were indeed and in fact being implicitly applied by the Advertisement Board based on accuracy and honesty principle, which is the main rule, I guess, around the world for advertisements, which is honesty and accuracy. So, but it is good, of course, to see that these principles and these provisions were explicitly enacted in a guideline and in the advertising regulation. Another important and prominent development is about consumer reviews. This was a topic which didn't have a specific legislation and specific rules. but they were subject to general advertising rules. Again, like I said, for the earlier slides and topics, but some specific rules for consumer reviews were introduced into Turkish law this year and by this amendment. Again, I listed some do's and don'ts for your summary and information. For example, only consumer reviews by consumers or işte customers who actually purchased the relevant product or service can be published. People who have not purchased the product or service are not allowed to publish consumer review. It is also obligatory to publish consumer reviews for at least 1 year. This is like the website. The vendors should publish the reviews for at least 1 year without making any positive or negative distinction. It is like some vendors or sellers can make distinction between the comments and only publish the positive one, and they can reject the negative ones, but the guideline tried to assure that all reviews should be published. Any consumer review which is found to be inappropriate for being published based on a predetermined criteria, of course, should immediately be notified to the consumer who made the review, so he or she can know why his or her comment has not been published. If a consumer's dissatisfaction is remedied, this should also be published within the same media. What is important is that fake comments and entering into such agreements by vendors are strictly prohibited. This is important, I guess, for assuring and protecting the consumers against fake comments, which is very common, in fact. Finally, what is important is again about health claims. It is banned to publish consumer reviews with health claims because this is a strictly regulated area under Turkish law. Let me go through the next. And there are also some specific rules about consumer complaints. What most important is that vendors or providers about whom the evaluation has been made will be given at least 22 hours to exercise their rights to make a statement or reply before the publication of the evaluation. And the media where these consumer complaints are published should provide the vendors and providers with an effective communication method so the vendors can use the right to make a statement or response against or regarding that complaint, and it shouldn't be subject to any subscription requirement. Finally, another development which recently entered into force in October 2 months ago is about the extension of advertisement board's authority. Well, there were some existing sanctions that the advertisement board is entitled to enforce, which are like issuing administrative fines, and they can be either cumulative or separately, issuing correction decisions, and or again temporary or permanent suspension decisions against the advertisements which infringe the advertising rules. In October, the advertisement board has been authorized to block access to the online broadcasts or contents which are found violating. This new authority considerably expanded the authority of the advertisement board, but the implementation of this rule is very new and recent. So the actual practice is expected to be settled in near future. We have not observed decisions of the advertisement board in this aspect yet. That's all, but one last word before finishing my presentation. What is the expectation for the next year? If you ask me, I can say something about I can say something about the trending topic in the world, around the world. I see that many countries are now focusing on environmental claims. Turkey is, I cannot say that Turkey is focused on these yet, but we recently observed some decisions of the advertisement board about the advertisements incorporating environmental claims. So we think that the advertisement board might issue a new guideline about advertisements with environmental claims for enlightening how they should enforce the advertising rules in relation to these claims. So this is what we expect for 2023 or maybe for, I don't have a certain time period for this. Yeah, all right, that's it for today. I hope you enjoyed, and I wish you all a very happy New Year. I know this is early yet, and thank you. Bye-bye.
Thanks, Baran. And I will bring it home to talk about developments in the United States. I decided to focus my comments on what's going on at the Federal Trade Commission. The FTC is, on the federal level, the primary agency that is authorized to both define regulations that interpret what is considered unfair or deceptive advertising and practices in commerce. It's also a law enforcement agency. It has significant tools to stop conduct that it considers to be violative, and also to penalize companies and persons, and to obtain restitution, typically in the form of refunds for consumers that have been quote unquote harmed by the deceptive or unfair conduct. It has been an extraordinary year at the FTC. Just some background, it is a commission. There are 5 commissioners who serve 7-year terms. Each commissioner is nominated by the President of the United States and confirmed by the Senate. Typically, it's 2 members are of the minority party, currently Republicans, and 3 are from the majority party, currently Democrats. But we had Commissioner Phillips resign this past fall to go back into private practice, and so we currently have 3 Democrats and 1 Republican. The chairwoman is Lina Khan, who is kind of came into public view when she wrote a piece about Amazon and how it violates antitrust laws. And she quickly ascended through the FTC and is now the chairwoman. She's been looking to expand how the FTC uses its authority. For example, we've seen announcements where the FTC has partnered with the National Labor Relations Board, which is a separate agency that deals with labor and employment issues, trying to meld the priorities of the labor agency and the FTC, seeing it all as related to consumer protection. Increased emphasis on individual liability under the FTC. It doesn't, under the FTC's laws that have developed through interpretations by courts, any control persons at a company can also be potentially in violation of the statutes for corporate conduct. And then the focus on dark patterns, which we'll talk a little bit more about, and dovetails with what Julika was talking about earlier. There have been, as we set up a commission with Republicans and Democrats reflective of the American society, there have been clashes between the Democratic majority and the Republican minority, with Commissioners Wilson and Phillips, now primarily Wilson, issuing very aggressive dissents for the various rulemakings and other decisions made by the FTC. So we're going to focus on the rulemaking because that is relatively unique to this last year. The FTC is known mostly as a law enforcement agency. interpreting its broad UDAP, meaning unfair, deceptive acts and practices authority, on a case-by-case basis against companies through enforcement actions. But it now is pivoting to bringing more and more rulemakings to provide more specific guidance as to what's considered an unfair and deceptive practice. Its authority to promulgate regulations comes from the FTC Act and other specific statutes that Congress passes. Section 18 of the FTC Act allows it to prescribe rules that define what is considered a UDAP. It's really, really time-consuming and hard to pass one of these regulations in the United States. I think the average is it takes 7 years, which is why the FTC had not been doing it for about 40 years and instead chose to use its authority by bringing enforcement actions and using those companies as examples for deterrence. But last year, the Supreme Court of the United States had a ruling that made it harder for the FTC to seek money against first-time violators. And so now it's pivoted towards rulemaking, which would allow it to obtain penalties and consumer refunds for first-time offenders. And so we'll go over in 7 minutes, some of the rulemakings that this commission under Chairwoman Khan has initiated. Each of these are in very early stages. As I mentioned, passing a regulation in the United States is very time-consuming and requires the agency to jump through many, many hoops, including getting industry feedback and taking that into consideration. It's unclear which of these regulations will ultimately go into effect. I suspect most will, but in pretty pared down versions than what the agency currently contemplates. The first is a regulation that would define what is considered an illegal earnings claims. An earnings claim, if it's not obvious, is any type of claim to induce people to take a job, start a business, invest in something. These have, these types of business opportunities, as we call it in the United States, have existed for a long time. But what is new, and what I think is causing some of this urgency to issue a regulation, is the gig economy and all these applications trying to recruit drivers and restaurant, all the workers that make up the gig economy workforce. We're seeing that the FTC has brought a few cases against those companies for making misleading earnings claims. So there's a regulation that's being proposed right now there. Another one is to make amendments to our telemarketing sales rule, which is an existing regulation that governs pretty much every aspect of telemarketing. It's a very powerful tool in the FTC's belt because it allows the FTC to get penalties, an injunction, and restitution. And there's also a provision in it that allows it to also bring cases for any person that provides substantial assistance to a company that violates the TSR. So again, a very powerful tool that the FTC uses anytime it could, if there's any nexus to telemarketing. The big one, talk about privacy, is the commercial surveillance and privacy rulemaking. For those of you that keep tabs on what happens in the United States, we don't have a comprehensive omnibus privacy statute. We have ones that govern medical data and ones that govern financial data, but we don't have an overarching statute. In the absence of that, we've seen some states, including California, issue their own comprehensive privacy legislation. And as a result, as more states pass these statutes, you have this patchwork of different requirements in different parts of the country. There has been attempts to pass federal legislation. We came very close this year. Ultimately, it didn't pass. In the meantime, the FTC said, all right, well, we will start the process of a regulation. Again, very early in the process, but it essentially would potentially cover every aspect of collection, transfer, and sale and monetization of data across any business and industry. So again, it's possible that Congress acts before this gets further along in the process. That might be part of the strategy at the FTC to push Congress to actually take up legislation instead of doing this by rulemaking. But we will see. And in the meantime, California has a brand new agency that's enforcing its statute. Given the size of California's market and economy, it's almost impossible to do business in the United States or the world without having to be in compliance with the California statute. There's also regulation being proposed on automotive advertising and what they're calling junk fees. Don't have too much time to cover that, but that's also another regulation in the works. The FTC also has informal guidelines that it's issued over the years interpreting, its broad UDAP authority. The endorsement guides, I think, have went into effect in 1980 and have been updated once since. They're up now for potential updating to kind of reflect what's been going on the internet. So, for example, changing the definition of endorser to include computer-generated influencers. So not real people, bots that are liking things, that would be considered an endorsement. To cover customer reviews, which is something that Baran talked about, also a big issue in the United States as to what customer reviews need to be published, what type of moderation can companies do when they have customer reviews, etc. So that is also something that the FTC has published for public comment and will likely finalize in 2023. We also have updates to our .com disclosures, which is a guidance on how to make disclosures online, both desktop and mobile. The FTC here is trying to attack what they call dark patterns. Dark patterns are interfaces and design features on websites and apps that are designed to steer customers to make purchase decisions that maybe they otherwise would not. Julika was talking about those timers, those countdown clocks. That's something that the FTC considers to be a dark pattern. Confirm shaming, when you say you don't want to buy the insurance and it says, are you sure you don't want to protect your travel? Those kinds of things are things that the FTC is looking at and as part of its .com disclosure updates. And then finally, really quickly, one of the kind of dark patterns that have been universally deemed as illegal is when consumers get enrolled in subscriptions without realizing it. So negative option marketing, which now touches everything. You can get a subscription to pretty much anything these days. The FTC issued a statement on how to do this correctly, what disclosures need to be included, how to get consumers informed consent to enroll in such a subscription. And then finally, you have to make it relatively simple to cancel a subscription. So the policy statement, if you're involved in any type of negative option marketing or subscriptions, provides a lot of detail about how to do that correctly and should be something on your desk. Also, something on customer reviews have been published, both for platforms that help aggregate reviews, but also for marketers. And the big takeaway there is that, as Baran said, you can't just publish positive reviews. There's also going to be, in 2024, additional updates that the FTC takes on. So with that, thank you all for joining us today for this whirlwind update on what's been going on in our respective countries. Gala has a ton of resources to help you navigate the globe. Here are some of the websites and blogs for your reference. I thank everyone that joined me today. And as Baran said, Happy New Year to everyone.
Happy New Year. Thanks for everything, Alexandra.
Take care, everyone.